Good afternoon, everybody. Good afternoon, good afternoon, good afternoon. Let me say hello to those in the chat for my 1 minute left. Good morning, good afternoon, good evening to everyone. Too cute. Hello. Hello, Tanya. Hello, Rhoda. Hello,
Hello.
hello, Red Bunny. Hello, Angela. Hello, Denitra. Hello, Demetria. Hello, Candy. Hello, Lala. Hello, Taz. Hello, Hildaland, please. Hello, Daryl. Oh, it's jumping. Hello, Butterfly Nest. Hello, Chanel. Hello, Auntie123. Hello, Gigi. Hello, Fifi. Hello, Anna. Hello, the Gym 353. Hello, Bree. Hello. I think that's it. I didn't see anybody else. Did I miss anybody? I don't. Did I say hello, Bread Bunny and Candy? I think I got everybody. Priscilla, hello, Black. Um, Kimberly Black, hello, Chris. Hello, Tish Tish. Hello, Timothy. I'm doing well this Wednesday afternoon. How? Hello. Let's see who else. I think I'm there. I'm at my 2 minute mark now. I am at my 2 minute mark. Those who are texting me, inboxing me, emailing me, please give me a moment. I cannot respond to anybody till after the live, okay? Till after the live. All right, T girl, hello. Hello, Shannon. Hello, everybody. I took a, well, hey, Valerie. Hey, Faith. Hello, Tiff J40. I took a well-deserved rest for a moment because uh, I was overwhelmed. I was overwhelmed by a lot of things, and I just needed to take some time away and steal away some moment to refresh and then regroup. Hey, Sherry. I'm back. I'm back, and in coming back on Hey Busy Bee, and coming back, I decide to do some little digging. And then I got my little partner in crime over here, Tanya. My
Hey,
partner
y'all.
in crime. And she, you know how she is. She's diligent in her research. Hey, Mimi. She's diligent. And the funny thing is, I contacted her earlier, and I said, I was thinking about what Jennifer said, and I was thinking about that Chambers versus Florida, and she's like, I was looking at it too. So I was like, okay, that means we're on one accord. So both of us are thinking the same thing. I want to give shout out to you digging me because she's the one who's like, well, maybe you should talk about this. So shout out to you digging me. I know she's probably in the bushes somewhere hiding, but shout out to you. So we all have been on one accord because we wanted to see take a look at the comment that Jennifer Bonjean or Bonjean. It's a French name, so I like to say both ways of Bonjean and Bonjean. So I wanted to take a look at that. We're not attorneys. We're just using our layman's ability to research. We're not saying what we're saying is concrete, but it's just giving us a little insight of um, what is being said. I love to research and trying to figure out some things. Hey, Sultry, I hope you had a wonderful birthday the other day. Hey, Stephanie. Hey, Sherry. So, hey, Latrice. So I wanted us to dig a little bit deeper. So she and I both was reading over some of the things and our thoughts, and I mean, we really was, you know, trying to figure out some of this stuff. But one of the things that I did come up with in regards to the 14th Amendment, because it kind of brought me back to the 14th Amendment when I looked at that case. The case is about these young men who was charged with a crime of killing a white older gentleman in Florida. And the whole case had to do with them, their rights being violated. They were treated unfairly. And we're going to depict some of the stuff that happened. We're going to read some things and tell you what, basically some of the violation that the higher court saw in that case, and that they made it become an actual law, part of case study. So the 14th Amendment is basically was originally the original purpose of the 14th Amendment was to protect the rights of former slaves and free blacks. This was made by a state governor to protect citizens' constitutional rights. Because when the Constitution was first originally written, it did not give people of color, black people, any kind of recognition. We were considered properties at that time when the original Constitution was written. So they had to make several different amendments. And one of the amendments that basically addressed blacks and free slave was the 14th Amendment, which should guarantee us the same rights as someone who is of a Caucasian background or persuasion. So it basically made it for our protection, because I'm saying our because I'm black. So it also limit the power of state government of after the Civil War. So because blacks fought in the Civil War and we were recognized at that point. So myself as well as Tanya, we did a little digging in regarding to that case, Chambers versus Florida, where the Supreme Court set an actual precedence case law in regards to that, so other cases could be looked at, from that point of view. So, without further ado, my girl, my reader, is going to
Okay.
first it's going to first read to you actually what that case is all about, Chambers versus the state of Florida. I'm going to show it here. Normally I have my trusty old watermark, but I didn't have time to do that today. So I'm going to just show it on the screen while she read it to you guys. I hope you guys get your pen and a piece of paper, so you guys, it's like a learning moment here. You know me, I'm like a teacher. I like to teach. But here it
Okay.
is. Here we go. It's
I
all
want to
yours.
okay, I want to first start out saying that it was argued on this case, Chambers versus Florida, was argued on January 4th of 1940, and they decided on it on February 12th of 1940. So the first part of it, I'll skip the top with all the attorneys and all of that. But number one about this case was the grave question presented by the petition for certiorari. I don't know what that, if I may not be pronouncing it right, but what that means is um, it is a writ or order by which a higher court reviews a decision of a lower court. It granted in forma pauperis is whether proceeding in which confessions were utilized and which culminated in sentences of death upon 4 young Negro men in the state of Florida failed to afford the safeguard of that due process of law guaranteed by the 14th Amendment. The number two is first, the state of Florida challenges our jurisdiction to look behind the judgment below, claiming that the issue of fact upon which petitioners base their claim that due process was denied them have been finally determined because passed upon by a jury. However, used by a state of an improperly or obtained confession by may constitute a denial of due process of law as guaranteed in the 14th Amendment. Since petitioners have seasonably asserted the right under the federal Constitution to have their guilty or innocence of a capital crime determined without reliance upon confession obtained by means proscribed by the Due Process Clause of the 14th Amendment, we must determine independently whether petitioners' confessions were so obtained by review of the fact upon which that issue necessarily turns. Second, the record shows about 9 o'clock on the night of Saturday, May 13th of 1933, Robert Darcy, an elderly white man, was robbed and murdered in Pompano, Florida, a small town in Broward County, about 12 miles from Fort Lauderdale, the county seat. The opinion of the Supreme Court of Florida affirming petitioner's conviction for that crime stated that it was one of the crimes that induced an enraged community. It's blacked out. And as the dissenting judge pointed out, the murder and robbery of the elderly Mr. Darcy was a most disastrous and atrocious crime. It naturally arose great and well justified public indignation. Between 9:30 and 10 o'clock after the murder, petitioner Charlie Davis was arrested, and within the next 24 hours, from 23 to 40 Negroes living in the community, including petitioners Williamson, Chambers, and Woodward, were arrested without warrants and confined in the Broward County Jail at Fort Lauderdale. On the night of the crime, attempts to trail the murderers by bloodhounds brought J.T. Williams, a convicted guard, into the proceeding. From then until confession were obtained and petitioners were sentenced, he took a prominent part. About 11 p.m. on the following Monday, May 15th, the sheriff and Williams took several of the imprisoned Negroes, including Williamson and Chambers, to the Dade County Jail at Miami. The sheriff testified that they were taken there because he felt a possibility of mob violence and wanted to give protection to every prisoner in jail. Evidence of petitioners was that on the way to Miami, a motorcycle patrolman drew up to the car in which the men were riding, and the sheriff told the cop that he had some Negroes that I don't know what that was, blank is, taking down to Miami to escape a mob. This statement was not denied by the sheriff in his testimony, and Williams did not testify at all. Williams apparently has now disappeared. Upon order of Williams, petitioner Williamson was kept in the death cell of the Dade County Jail. The prisoners, thus spirited to Miami, were returned to Fort Lauderdale Jail the next day, Tuesday. It is clear from the evidence of both the state and petitioners that from Sunday, May 14th to Saturday, May 20th, the 30 to 40 Negro suspects were subject to questioning and cross-questioning, with the exception that several of the suspects were in Dade County Jail over one night. From the afternoon of Saturday, May 20th, until sunrise on the 21st, petitioners and possibly one or two others underwent persistent and repeated questioning. The Supreme Court of Florida said the questioning was in progress several days and all night before the confessions were secured, and referred to the last night as an all-night vigil. The sheriff who supervised the procedure of continuing interrogation testified that he questioned the prisoners in the daytime all the week, but did not question them during any night before the all-night vigil of Saturday, May 20th, because after having questioned them all day, he was tired. Other evidence of the state was that the officers of Broward County were in that jail almost continually during the whole week, questioning these boys and other boys in connection with this case. The process of repeated questioning took place in the jailer's quarter on the fourth floor of the jail during the week following their arrest and until their confession was finally accepted to the state's attorney in the early dawn of May 21st, Sunday, May 21st. Petitioners and their fellow prisoners were led one at a time from their cell to the questioning room, quizzed, and returned to their cells to await another turn. So far as appears, the prisoners at no time during the week were permitted to see or confer with counsel or a single friend or relative. When carried singly from his cell and subject to questioning, each found himself a single prisoner surrounded in a fourth floor jail room by 4 to 10 men, the county sheriff, his deputies, a convict guard, and other white officers and citizens of the community. The testimony is in conflict as to whether all four petitioners were continually threatened and physically mistreated until they finally, in hopeless desperation and fear of their lives, agreed to confess on Sunday morning just after daylight. But that as it may, it is certain that by Saturday, May 20th, 5 days of continued questioning had elicited no confession. Admittedly, a concentration of effort directed against a small number of prisoners, including petitioners, on the part of the questioners, principally the sheriff and Williams. The convict guard began about 3:30 that Saturday afternoon. From that hour on, with only short intervals for food and rest for the questioners, they all stayed up all night. They bring one of them at a time, backwards and forwards, until they confessed. And Williams was present and participating that night, during the whole of which the jail cook served coffee and sandwiches to the men who grilled the prisoners. Sometime in the early hours of Sunday, the 21st, probably about 2:30 a.m., Woodward apparently broke, as one of the state witnesses put it. After a 15 or 20-minute period of questioning by Williams, the sheriff and the constable, one right after the other, the state's attorney was awakened at his home and called to the jail. He came, but was dissatisfied with the confession of Woodward, which he took down in writing at the time, and said something like, "Tear this paper up. This isn't what I want. When you get something worthwhile, call me." The same state's attorney conducted the state's case in the circuit court below and also made himself a witness, but did not testify as to why Woodward's first alleged confession was unsatisfactory to him. The sheriff did, however, the lieutenant says, A, no, it wasn't false. Part of it was true, part of it wasn't. Mr. Muir, the state's attorney, said there wasn't enough. It wasn't clear. And then it goes down to the question, was that voluntarily made at the time? The answer was yes, sir. The question was, it was voluntarily made at that time. Yet the answer was yes, sir. The question was, you didn't consider it sufficient. And he answered, Mr. Muir, and the question was, Mr. Muir told you that it wasn't sufficient, so you kept on questioning him until the time you got him to make a free and voluntary confession of other matters that he didn't include in the first. And his answer was, no, sir. We questioned him there and we caught him in lies. And the question was, caught all of them in lies? And he said, caught every one of them lying to us that night. Yes, sir. The question is, did you tell them they were lying? And he said, yes, sir. And he asked him, just how would you tell them that? And he said, just like I'm talking to you. And he said, you said, Jack, you told me a lie? And he said, yes, sir. After 1 week's constant denial of all guilt, petitioners broke. Just before sunrise, the state officials got something worthwhile from petitioners which the state's attorney would want. Again, he came, in the presence of those who had carried on the witnesses and witnessed the all-night questioning. He caused his questions and petitioners' answers to be stenographically reported. These are the confession utilized by the state to obtain the judgment upon which petitioners were sentenced to death. No formal charges had been brought before the confession. 2 days thereafter, petitioners were indicted, were arraigned, and Williamson and Woodward pleaded guilty. Chambers and Davis pled not guilty. Later, the sheriff, accompanied by Williams, informed an attorney who presumably had been appointed to defend Davis that Davis wanted his plea of not guilty withdrawn. This was done, and Davis then pled guilty. When Chambers was tried, his conviction rested upon his confession and testimony of the other three confessioners. The convict guard and the sheriff were in the courtroom sitting down in a seat, and from arrest until sentence to death, petitioners were either in jail or in court, wholly removed from the constant observation, influence, custody, and control of those who persisted pressure brought upon the Sunrise Confessions. Third, the scope and operation of the 14th Amendment has been fruitfully sources of controversy in our constitutional history. However, in view of its historical settings and the wrongs which called it into being, the due process provision of the 14th Amendment, just as that in the fifth, has led few to doubt that it was intended to guarantee prosecutorial standards adequate and appropriate then and thereafter, to protect at all times people charged with or suspected of crime by those holding position of power and authority. True, true, let's see, I know that word. Tyrannical governments have immemorially utilized dictatorial criminal procedures and punishment to make scapegoats of the weak or of helpless political, religion, or racial minorities and those who differ, who would not conform, and whose resistant tyranny. The instruments of such governments were in the main to conduct innocent when engaged in were I don't know what is going on with me this morning, subsequently made by flat criminal punishment punishable without legislation, and a liberty loving people who won the principle that criminal punishment could not be inflicted saved for that which proper legislative action had already by the law of the land forbidden when done. But even more was needed. From the popular hatred and abhorrence of illegal confinement, torture, and extortion of confession, a violation of the law of the land involved the fundamental idea that no man's life, liberty, or property be forfeited as criminal punishment for violation of that law, and there has been a charge fairly made and fairly tried in public tribunal, free of prejudice, passion, excitement, and that's what she said, right, Miss Sylvia?
Yes.
Ah, okay. Thus, as assurance against ancient evils, our country, in order to preserve the blessing of liberty, wrote into its basic law the requirement, among others, that the forfeiture of the lives, liberty, or property of people accused of crimes can only follow its procedural safeguards of due process have been obeyed. The determination to preserve an accused's rights to procedural due process sprang in large parts from knowledge of the historical truth that the rights and liberties of people accused of crimes could not be safely entrusted to secret inquisitorial processes. Ah,
Mm.
mm. So it can't be. You can't secretly try someone, is what it's saying, right?
Mm-hmm.
The testimony of centuries in governments of varying kinds over populations of different races and beliefs stood as proof that physical and mental torture and coercion had brought about the tragically unjust sacrifices of some who were the noblest and most useful of their generation. The rack, the thumbscrew, the wheel, solidarity,
Solitary.
solidarity, salt.
Solitary.
Okay, yeah, let me make this bigger. Hold on.
Solitary confinement.
Yeah, see, I'm making it bigger. I'm sorry. Solitary confinement. God, Tony, that's so dumb. I should have had this bigger longer. Solitary confinement, protracted questioning and cross questioning, and other ingenious forms of entrapment of the helpless or unpopular had left their wake of mutilated bodies and shattered minds along the way to the cross, the guillotine, the stake, and the hangman's noose. and they who have suffered most from secret and dictatorial proceedings
Mm.
have almost always been the poor, the ignorant, the numerical weak, the friendless,
Friendless.
and the powerless.
Mm.
This requirement of conforming to fundamental standards of procedural in criminal trials was made operative against the states by the 14th Amendment, where one of the several accused had limped into the trial court as a result of admitted physical mistreatment inflicted to obtain confession, upon which a jury has returned a verdict of guilty of murder. This court recently declared, Brown versus State of Mississippi, that it would be difficult to conceive of methods more revolting to the sense of justice than those
Mm.
taken to procure the confessions of those petitioners, and the use of confessions thus obtained as the basic for conviction and sentence was a clear denial of due process.
Process.
Here, the record develops a sharp conflict upon the issues of physical violence and mistreatment,
Treatment.
but shows without conflict the dragnet methods of arrest on suspicion without warrant, and the protracted questioning and cross questioning of those ignorant young colored tenant farmers by state officers and other white citizens in a fourth floor jail room, where as prisoners they were without friends, advisors, or
Mm.
counsels, and under circumstances calculated to break the strongest nerve and the stoutest resistance. Just as our decision in Brown versus State of Mississippi was based upon the fact that the confessions were the result of compulsion, so in the present case, the admitted practices was such as to justify the statement that the undisputed fact showed that compulsion was applied. For 5 days, petitioners were subject to interrogation, culminating in Saturday, May 20th, all night examination. Over a period of 5 days, they steadily refused to confess and disclaimed any guilt. The very circumstances surrounding their confinement and their questioning without any formal charges have been brought were such as to fill petitioners with terror, frightful misgivings. Some were practical strangers in the community. Three were arrested in a one-room farm tenant house, which was their home. The haunting fear of mob violence was around them in an atmosphere charged with excitement and public indignance. For from virtually the moment of their arrest until the eventual confessions, they never knew just when any one of them would come back to the fourth floor room and there, surrounded by his accusers and others, interrogated by men who held their very lives, so far as those ignorant petitioners could know in the balance. The rejection of Petitioner Woodward's first confession, given in the early hours of Sunday morning because it was found wanting, demonstrates the relentless intensity which broke petitioners' will and rendered them helpless to resist their accusers further. To permit human lives to be forfeited upon confession, thus obtained, would make of the constitutional requirement of due process of law a meaningless symbol. We are not impressed by the argument that law enforcement methods such as those under review are necessary to uphold our laws. The Constitution proscribes such lawless means irrespectable of the end, and in this argument flouts the basic principle that all people must stand on an equality before the bar of justice in every American court. Today, as in ages past, we are not without tragic proof that the exalted power of some governments to punish manufactured crime dictatorially is the handmaid of tyranny. Under our constitutional system, courts stand against any winds that blows as havens of refuge for those who might otherwise suffer because they are helpless, weak, outnumbered, or because they are non-conforming victims of prejudice and public excitement.
Mm. Mm.
Hmm.
Mm.
Jenny from the block is not playing.
Okay, go ahead.
Due process of law, preserved for all by our Constitution, commands that no such practice as that disclosed by this record shall send any accused to his death. No higher duty, nor no more solemn responsibility rests upon this court that than that of translating into living law and maintaining this constitutional shield, deliberately planned and inscribed for the benefit of every human being subject to our Constitution, of whatever race, creed, or
Persuasion.
persuasion. Yes, the Supreme Court of Florida was in error, and its judgment is reversed. Mr. Justice Murphy took no part in the consideration of decision of this case. Wow, good job. So
All
it
right.
says,
Now let's kind of let's go to the other one, and then we're gonna break down some of the stuff, our thoughts in this. This is not an attorney. We're not attorneys, but I just want to break down some of the thoughts that we have here. Okay.
okay, but we're going to read the right to a fair trial.
Okay. Hold on. Hold on. Let me bring it up. Let me bring it up. Hold on. Hold on. Gotta bring it up. Got to bring it up. Here we go. All right. Gotta go back up. All right. Here it is.
Okay, so Article 6 in the Constitution is a right to a trial, to a fair trial. Article 6 protects your rights to a fair trial. You have the right to a fair and public trial of hearing if you are charged with a criminal offense and have to go to court, or a public authority is making a decision that has an impact upon your civil rights or obligations. In this context, your civil rights and obligation of those recognized in areas of, is that UK law?
Yeah, but we gotta go past that.
Okay, anyway, okay. So I'll go down to what is fair in public hearing. What is a fair and public hearing? You have a right to a fair and public hearing that is held within a reasonable time, is held by an independent and impartial decision maker, gives you all the relevant information, is open to the public, although the press and public can be excluded for highly sensitive cases, allows you representation and an interpreter where appropriate, and is followed by a public decision. You also have a right to an explanation of how the court or decision making authority reached its decision.
Mm.
What rights do you have at a criminal trial? You have a right to presume innocent until you're proven guilty, to be told as early as possible what you are accused of, to remain silent, have enough time to prepare your case, legal aid funding for a lawyer if you cannot afford one, and this is needed for justice to be served, attend your trial, access to all the relevant information, put forward your side of the case at trial, question the main witnesses against you and call other witnesses, and have an interpreter if you need one. Everybody must have equal access to the court under the Human Rights Act. This includes a right to bring a civil case, a case between individuals or organizations, although this right can be restricted in some situations. And it says, are there any restriction to this right?
Well, we don't need to read that because
No,
it's
we
not.
don't.
Okay, let's go
None
down
of
to the
this.
bottom. And here's go
What the
down.
law says. Article 6, it says, Article 6 is a right to a fair and public hearing. In determination of civil rights and obligation of any criminal charge against him, everyone is entitled to a fair and public hearing within a reasonable time by an independent and impartial, wait, let me see,
Tribune.
tribune established by law. Judgment shall be pronounced publicly by the press, and public may be excluded from all or part of the trial in the interest of morals, public order, or national security in a democratic society, where the interests of juveniles or the protection of private life of parties so require, or the extent strictly necessary in the opinion of the court in special circumstances where publicity would prejudice the interests of justice. Everyone charged with criminal offense shall be presumed innocent until proven guilty according to
Presume,
the law,
presume innocent. That's right. Go
until
ahead.
proved guilty. Everyone charged with a criminal offense has the following minimal rights: to
Minimum.
mhm, to be informed promptly in a language which he understands and in detail of the nature and cause of the accusations against him, to have adequate time and facilities for the preparation of his defense, to defend himself in person or through legal assistance of his own choosing, or if he has no sufficient means to pay for legal assistance, to be giving it free when the interests of justice so require, to examine or have examined witnesses against him, and to obtain the attendance and examinations of witnesses on his behalf under the same conditions as witnesses against him. To
Same
have
conditions.
same
Same
conditions.
conditions. Okay.
Yep. To have free assistance of interpreter if he cannot understand or speak the language used in
In court. Okay. What happened to you, Tanya? She disappeared, y'all. Okay, but that is the right to due process. Okay. Now, Tanya, you there? Are you there? All right, let's have a discussion. I don't know what's going on with her thing. I'm gonna kick her out and maybe she'll come back in. I'm gonna kick you out, come back in. All right. Here's we're gonna have a discussion in regards to Robert case. Some of the things that I've shown you guys in the past couple of weeks, and also stuff that we have, known. Okay. We're gonna start off first what his first right was violated. The case that was brought up against him was done by number one, Surviving R. Kelly. Surviving R. Kelly was a production which was never verified. It was never the people that was given stories were never there was never police report placed out. There was nothing done that was according to court procedural. Okay, they brought it out, and that production touched millions of household. Millions of household. I'm just gonna tell you, million. It touched so many household that it won several awards. Did it not? It won several awards. So there was no possible way for Mr. Kelly to have a fair trial in the United States. I don't care what they say. The best place would have been someplace in another country that don't have television. That would be the only way for him to have a fair trial. Okay. Not only did they do that, they solicited people to call in for crime
created
that
a
was never.
hotline.
Yeah, they created a hotline to call in. It was like a mob lynching in the public arena, a mob lynching. And there were people who were uh, going for political offices or getting their term re-up, like going back for another term, that was doing the solicitation for people to come and press charges or make accusation. Okay. The other thing is his attorney did not have access to the people that supposedly going against him until like the last minute they started putting names in. They just put Jane Doe's. You didn't know which Jane Doe would belong to which. They were switching and putting people in, taking people out. I mean, so many unfair tactic that was done by the government, whoever it is that was in charge of this. There was so many things. Not only that, listen to this, guys. While in jail, that man endured uncruel punishment. He was beaten up. People was looking into his personal informational, selling his stuff, giving it out to a big blogger. The big blogger was fueling negativity and giving all the stuff that was against him to the public. There's so much what do you call it, uh, appropriation of justice that occurred in Mr. Kelly's case. You have people doing things based on rumor and in the windows. That's how he got conviction, not because of facts. Because even during trial, you did not see the videotape that they talked about. The underage girl they talked about, it was not presented during the trial. I'm telling you guys. But they got a conviction. They got a conviction because of a television show. And not only did they do the television show once, they did it twice. Now they get ready to do it another time. And they're doing it right before another trial start. And this is no other human being ever had a documentary before actual. Most of the time documentary happens after the person has been tried or been in jail. This was done before he even got charged. No one ever, this never happened to anybody. This has never been done to anybody. You tell me one person that an actual documentary was done before the person was even charged, and then they turn around and solicit people. Tell me one. Tell me one. Tell me one person that has been done to, a mob lynching like this. Everybody convicted him before he even went to trial. You guys, you are witnesses how many YouTubers and national news was putting him as a convicted person. They gave him names. They threw out hint names that was putting in your head that he is guilty. Disgraced singer, predator, pedophile, all these negative names that they were utilizing in this man's image. All you kept seeing is that. So how can he have a fair trial and a jury of 12?
Miss Sylvia, I just sent you something. It's
Okay.
another thing I had saved. That it was in Alaska, whatever, but it was based upon pre-trial publicity. How this person in this particular case, it was they were saying that because of the public opinion, it was going to be hard for this person to get a fair trial because of this publicity.
Okay, you
So
want to read it? Let me bring it up so you can read
yeah,
it.
let me just I'm gonna read some of it, and it's just gonna
Okay,
give
I'm
you
gonna bring it
guys.
up. Hold on a second. Hold on a second. Let me bring it up. Okay, hold on, guys. Okay, here we go. I'm gonna make it show and share it.
And I'm gonna start at the introduction where
Okay.
it
All right,
says,
here we go.
okay, so this is a case that was talking about that this person had maybe prejudice before his pre-trial. So it says on October 19th of 1990, Raymond Sheely was driving on Glen Highway in Anchorage, Alaska with two friends, Doug and George. Grafferson was holding a HK-91 semi-automatic rifle in the front seat after an incident with another car on the highway. He fired a shot at another vehicle, killing the passenger. This incident marked Anchorage's first drive-by shooting and sparked a great deal of publicity. Sheely filed a motion for a change of venue outside of Anchorage. In support of his motion, he submitted more than 24 newspaper articles that addressed the shooting, the arrest of the defendants, and the trial and conviction of co-defendant Gufferson. The coverage described Sheely as a lead troublemaker and a group leader, and both men were labeled gun nuts. Several articles stated that Cheeley maneuvered the car so that Gufferson could get a clear shot, that police suspected Cheeley hid the murder weapon, and that both men had threatened others not to testify against them. The article also discussed a burglary and theft that the two men were suspected of committing. Despite the intense media coverage, the court ruled that a change of venue was not required. Cheeley was convicted of second-degree murder and sentenced to 16 years imprisonment. The struggle to protect criminal defendants charged with sensational crimes from exposure to the media circus can be traced in American jurisprudence back to the trial of Aaron
We
Burr
can't
in
really
eight.
hear you. You sound like you're muffled.
Oh, okay. I'm sorry. I'm sorry.
Okay.
Sorry.
Okay, go ahead now.
I'm gonna say the former vice president had been charged with treason for planning the seizure of New Orleans, and the invasion of Mexico in defiance to President Jefferson. The charge of treason against Colonel Burr was the focus of the media and saturated Virginia's papers, which informed the jury in great detail of events and procedures leading up to the trial. The Virginia press described a purported grand plan of insurrection where Burr would invade Mexico, detach the Southwest from the United States, and form an empire stretching from Mississippi Valley to Mexico. The Supreme Court Chief Justice John Marshall, who presided over Burr's trial, had to confront the effect of pre-trial publicity on the prospective jurors. The concern was that the concern was and is that pretrial publicity will impair the Sixth Amendment, guaranteed that in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district within the crime shall have been committed. In his opinion, Chief Justice Marshall recognized the importance of an impartial jury. And what that says is the great value of trial by jury certainly consists in its fairness and impartiality. Those who most prize the institution prize it because it furnishes a tribunal which may be expected to be uninfluenced by an undue bias of the mind. Why do personal prejudice constitute a just cause of challenge? Solely because the individual who is under their influence is presumed to have a bias on his mind, which will prevent an impartial decision.
Mm,
That's the surviving R. Kelly. So
mm.
everybody in the world probably has seen this.
Yep.
So
Yep.
this is a case where they were saying that because of the publicity, this they couldn't have had a fair trial.
And then they even try to say not to mention anything about his previous proceedings and stuff like that, but they still brought it up. They still brought it up some kind of way, and it was absolutely no way Robert could get a fair trial, even if they move it to a different venue. That those people in those areas, there were millions of homes that saw surviving R. Kelly, millions of homes, and if they didn't watch it, somebody around them was talking about it.
Yeah, I'm gonna go down here where it says while Chief Justice Marshall
Hmm.
was clearly concerned about protecting the defendant's express right under the United States Constitution, he also recognized that both procedural and substantive justice can be compromised by an underlying immutable fact of human nature. The opinions of others can inform and
Yep.
direct the decision of juries,
Hmm.
often in subtle ways impossible to detect in a public courtroom. Acknowledgement of this fact is an inherent component of the court's duty to ensure overall justice. Otherwise, regardless of how fair the actual procedure and the subsequent results appears, the integrity of a jury verdict and thus the justice system will always be questioned in an environment populated by suspicion of bias.
Hello.
Consequently, Chief Justice Marshall also realized that the trial court has a duty to independently assess and possibly resume partiality, even in spite of a jury's denial of bias.
Mm.
The Chief Justice began a rigorous uh, voir dire of prospective jurors on August 3rd of 1807. 48 prospective jurors were examined the first day, and 44 were excused after admitting to being influenced by the newspaper.
Mm.
After 2 weeks of the voir dire, the panel and
Hold on a
prospective.
second, Tanya. How long did it take them to pick a juror for Robert? How long
Not
did
that
it
long.
take them, y'all? Okay,
How
I'm
long
not
was it?
answering calls. People, stop calling me, please. Don't call me. I'm not taking calls. Oh my God. Ugh, I am not taking calls. Sorry. I'm not taking calls. Whoever's online, I'm not taking calls right now. All right, sorry about that. Now, say, how long did it take them to pick a jury for Robert? How
I
long did it
don't.
take them? They were given a whole week. They never took a whole week.
Nope.
They never took a whole week. They took a couple of days. And you see how long it's been taking the ones over here in Georgia to pick the jurors? They're taking a long
Hmm.
time to pick the jurors for these three guys. But
And it
look what
says,
they did to Robert. Only a
hmm
few days.
yep. After 2 weeks of voir dire, the panel of prospective jurors were exhausted, and a second veneer was summoned.
Thank
Chief Justice
you.
Chief Justice Marshall did not disqualify jurors for having information and opinions on the case, so long as the repossessions was a light impression that may leave the mind open to a fair consideration. This rule was applied both to views on the full case and views of an essential element of the charge. Furthermore, regardless of what jury claimed, it was up to the court to determine the degree of the jurors' foregone conclusion of the defendant's guilt.
There it is, right there, y'all. There it
Yeah.
is. Go ahead. There it is.
It says, unfortunately, Chief Justice Marshall's efforts to confront the bias of jurors did not distinguish between presumed and actual prejudice. The only tool available to him to ferret out the impartiality of the judge was his own tenacity veneer. However, the sole use of the veneer is inethical to the presumption of prejudice analysis. If pretrial publicity has so premated a community such that prospective jurors cannot adequately accesses the depth to which the editorial journalism has infiltrated their minds, the
Mm.
jury of a jury panel from the community can be fertile exercise. Therefore, unless prejudice is presumed, the judge will be making a decision based upon information from untrustworthy
Untrustworthy. That's it.
sources. And as a result, the integrity of the process will
Will be
be compromised.
compromised. That's right. Hello. All right, go ahead.
Yes. I know. So I was looking over this and found this. I'm like, wow. Nevertheless, in 1878, the Supreme Court entirely removed the concept of presumed prejudice from inquiry into jury impartiality. In Reynolds versus United States, the Supreme Court established that a finding of jury bias must be based on actual evidence that a jury had clearly formed a biased opinion. You see how they changed it?
Mm-hmm. Mm-hmm.
So let me just say this, Miss Sylvia. I think Miss Jennifer Bonjean, what she's going to do is hit them with laws.
That's right.
I don't even think she's going to attack the witnesses. I think she's going to base this upon laws and his rights that were violated.
That's
So,
right.
yeah, that's what
That
I
is
think.
right. But see, I mean, you guys, guys, the ones that are here in this chat, we had over 205 people in this chat. Now, you tell me if you believe that those jurors came out where they really, really did not have a bias before going into this trial. There's no possible, because with all the evidence that they had, they didn't even, I mean, they didn't even have a hung jury, guys. They convicted him on all 9 counts. How possible is that? On a RICO, a RICO. Guys, I'm not taking, oh, hold on, that's Dallas. I thought it was somebody else calling. Hold on a second. Go ahead, Tanya, talk to them.
Okay, I'm going to read this other. The article argues that though historically the most popular approach for Vadir is neither an appropriate nor effective initial step in which in what must be a two-step inquiry into jury prejudice. First, prior to the jury selection process, trial court needs to examine carefully the possibility of presumed prejudice when the issue is raised. Second, if necessary, okay, so I don't even think they raised the issue. The attorneys raised the issue of prejudice because of, okay. Second, if necessary, actual prejudice should be separately explored during voir dire. The separate analysis for presumed and actual prejudice is especially critical. So what it's saying here, did the defense raise the question that the jury could be prejudiced?
That was I know it was in the questionnaire. They redid the questionnaire to add in certain things. I know they added in about the same sex type of thing. But as far as the other things, I'm not too sure.
Because
But
of the publicity and the
yeah,
surviving R. Kelly.
guys, there was so much publicity against Robert. I don't care what nobody said. Even with the prosecutor, Kim Fox, doing what she did. I
And then not
mean,
only that, you guys mute R. Kelly. Everybody knows about mute R. Kelly. The Me Too. You guys stopped him from making money before this. You
exactly.
even
They already
charged him with anything.
exactly. And then the other thing, every time you turn around, you kept hearing about Aaliyah, and you kept hearing about the sex tape. The sex tape, which he was found not guilty, but they still bringing that about. I mean, I can't understand how this man could even get a fair trial whatsoever, because they're trying to do something that was already tried and he was not convicted, and then they're going to bring that back up. They brought it back up in the case. They brought Aaliyah up. Aaliyah's deceased, dead, can't even get on the witness stand herself. The parents did not get on the witness stand for Aaliyah's situation. They get a convict who's the one who admit to him buying the ID to testify against Robert. I mean, this stuff here does not make sense at all.
I'm
It does
gonna
not
read
make
this.
sense.
I'm gonna read this. It says, in conclusion, the author suggests that principles of justice are threatened by the failure to differentiate between presumed and actual prejudice. They further argue that in an era of rapid advancing methods of communication, Alaska courts must, at a minimum, give due consideration to the need for an independent analysis of presumed prejudice when deciding on proper venue for high-profile criminal cases. Voir
Mm-hmm.
dire should never be the basis of a presumed prejudiced inquiry. Lastly, when prejudice can be fairly presumed, trial courts should not hesitate to change the venue. The large geographical expansion offers many alternative sites where pretrial publicity would not be an issue. Okay, yeah. Okay, go ahead, Miss Sylvia. I'm talking. Let me read some more down here before
Now, so I was up to you where you were.
but I'm gonna read through here some more and see what I can point out.
Okay.
I'm not gonna read it all. I'm just gonna point out some stuff.
The motion have to be strategically written with law and case reference. This is why Mr. Who okay. I don't know why you trying to Carolyn, I don't understand why you have these type of names for someone. That is inappropriate, Carolyn. I don't know who you are, but please, let's not do that.
Well, Miss Carolyn, I'm almost for certain that they understand that. So I'm sure Miss Bonjean knows exactly what she's doing.
These people, man, I tell you, ooh, Lord have mercy. We needed to pray over some of these folks up in here. Woo, Jesus.
I have
Jesus.
never, ever in my life seen a society that wants one single man to be so wrong because they put in the words, he was in the sentence, he was messing with children. That is not the case.
It has not been proven. It has not been proven. These are all accusation.
I saw a couple, they were ministers or whatever on YouTube. I just kind of glanced through them, and they were saying how awful R. Kelly was. I'm not going to listen to him because this, and that. In my mind, I'm thinking, why are you? So you guys, first of all, the Bible says you should not judge. So you over there judging somebody. You haven't, and most of their stuff that they were talking about was hearsay. I heard this, I heard that. Did you check any of this hearsay stuff that you said that you're talking about? You're going over YouTube talking down on this man and you don't have no facts of the case. You going off of hearsay and you call yourself ministers and pastors and all that stuff. First of all, you shouldn't have an opinion that broad to where you got to make a YouTube video on it about something that you know nothing about. Make one on the Catholic priest. Those are proven cases. Don't do it with this because you don't know what you're talking about. It's just crazy.
Well, this is what I wanted to just bring you guys. I didn't plan on staying here too long because I'm not doing this long, drawn out stuff with you guys anymore. I'm not. I'm not getting here trying to argue with folks back and forth about anything. I'm just giving you what the law says, what has precedent, and what which I know this case will be overturned. I know without a shadow of a doubt, because the treatment this man has received, the treatment that this man has received. Yeah, people can have an opinion. You're right. You're right. People can have an opinion, but I didn't ask for an opinion. We're just giving you some information. You can do whatever you want to on your side, behind your scene, behind wherever you are. You can do that. All I'm doing is bringing you information. All this extra argument with me, I'm not arguing with you. I'm not going back and forth with you or anybody else. I'm not doing it. I'm not having a opinion panel right now. We're just bringing you facts. We saw that the statement that she made, the comment she made, and we wanted to do research on the comment and bring it forth to you guys. Now, what you do on there, it's on your own. This is not a debate here. This is not a debate. This is just information. You eat the meat and you spit out the bones. That's what you do. Now, if you disagree, that's fine. You have a nice day. But all this extra stuff going back and forth with me and Tanya about stuff, I don't need that. Nope. Keep your comments to yourself.
We're just actually trying to put something out here for people to do some research, eventually on your own to get your mind to see exactly what happened. It's not to force an opinion on anyone. It's to put the information out there so you can research yourself and gather your own opinion. We all have our free will. I mean, we can believe it or we can't believe it, but if you do your research, you can determine whether you want to or not from that. What you see with your own eyes, not what someone's told you.
Yeah. Connie Moore, you just got yourself blocked because I'm not arguing with you back and forth. I don't care what you say. I'm not arguing with you back and forth. Have a nice day. They have brought out the nasty Sylvia because it seems as if when you're nice to people, they think they could come in and run you over and do whatever and say whatever they want to say. I'm not dealing with that. Not today, not ever again. I just brought out the nasty Sylvia.
Don't let the devil win, Miss Sylvia. I know.
That's why I took time off of this YouTube stuff. I took time off because I'm tired of the nonsense. I'm giving you what we research, and if you want to research on your own, you go ahead on, continue. Research on your own. I don't need to hear all that extra stuff. Not arguing with people. Not letting my blood pressure go up with people. Not anymore.
No, no, no,
Not doing
no.
that anymore. Hey, Jan. There go my girl. I haven't seen her in ages. Oh,
Denise, how are you?
I have to get a little sunshine sometime. People like Mimi, Jan, and you digging me. Sometimes I need the friendly faces in here. Sometimes just pop up in here once in a while, y'all. Because when the devil, oh, woosah, woosah, I
Take
gotta
a
listen.
deep breath.
I do. I'm telling you, the last couple of days has really done something to me. Has put me in another level that I'm not no nonsense now. I'm at no nonsense. I'm not. Nope. Call me dictator or whatever you want to call me. I'm there now. I don't want. I'm not dealing with it. Not. I'm not. I'm not dealing with it. Seriously. Because I'm not here for you to like. You don't like me anyway, so be gone. Poof.
We don't care.
I don't.
No, we don't care. Not entertaining. First of all, this side of the channel is
You
for
could.
information.
Yes, you could be out without saying you're out. There's no reason for you to announce I'm out. Bye. I don't
The
get it. Oh, I heard enough. I'm out. Bye. You ain't got to announce yourself. Just leave.
well, this channel is for information purposes. There's 188 people watching from what I see, I guess.
190.
So
191.
190? Yeah. This this page is for information purposes, not to debate or
I'm not debating with people.
none of that stuff because it's not necessary, guys. We're giving nothing that we've said this morning would cause for a debate of anything if you haven't researched on your own. It's Miss Sylvia said at the very beginning, get your pen and paper out and take notes if you'd like. That way you would have your information to go do your own research, right?
Mm-hmm.
So, no one in here in this chat will steal either of our joy because we are highly blessed and favored.
But the funny thing is, they hop in here to get information, then they got to make the comment. Just leave. Nobody knows you're here. You just take it, whatever it is, bye, and go on about your business. I don't get it.
We will continue to press on.
Yes, Kimberly, we will continue to press on. We will continue to press on. Oh yeah, I need to take that, but let me check my blood pressure because I.
Yes, please. Where is it? We need to see it. We need to see it before you get off of here,
Let me
sister.
check my blood pressure because folks be just like trying to get that blood pressure up. I have a very good blood
Thank you,
pressure.
Jan.
Hey, putty dad. Hey, baby girl. There she is. Hey, glamour girl. I had to put on my. Hold on. Let me put this thing on. See how my blood pressure's up. Let me put the batteries in here. Hold on. Gotta put the batteries in here because you're supposed to be getting my blood pressure up. I can't do that. I gotta do some laughter here, y'all. We need some laughter because my blood pressure was boiling a few seconds ago.
I know, because I honestly think that people are losing focus, right?
Yeah.
Focus for what the purpose of all of this is. The purpose and the for all of these different channels was supposedly be for one man. And then once he was convicted, the purpose was for it to be about two laws, right? So the law that we're really focusing on is the Mann Act. So it was free Robert and the injustice that he was getting. Now that he's been convicted, we have to focus on getting him out of this mess and demolishing the Mann Act. That is what our purpose and our focus is, right? So when people come in here with all the BS and they want to go back and forth and want to debate or whatever, it's not necessary. I think you guys can stay
Oh,
in the
Miss
bushes.
Fat, excuse me, Miss Fat's 126 over 84. Is that okay?
Yeah, you.
It's still not, it's a little high at the bottom there, Miss Fat. How is that, Miss Fat? 126 over 84. That's perfect. Okay, okay. They didn't get me too up there, too high up there.
Yeah, that's
All
good.
right. Yes, abolish the Mann Act. That's what we, guys, make sure you sign that petition for the abolishment of the Mann Act. We have that petition going around.
And also, I wanted to ask how many people have reached out to their congressperson within their state?
I don't think any.
Um, I put in the chat the other day who the two people were for Texas
Mhm.
that people needed to reach out to in reference to this act, whether it be calling or emailing them or something. Just send something just to put it in people's faces. If they see enough emails, get enough phone calls about it, they're like, we may need to look at this. I have not seen the screen when you said that. Oh,
I think that if people can connect to people that are in their states and they do it as a group, it will bring more impact than one
yeah,
individual. That is so true,
yes,
that Glamour.
yeah,
Yep,
you're
you're right.
right. Jan, I'll put it in again. Let me,
Where we need to put up the
who our congresspersons are for our states.
oh, okay.
I think for Texas.
Okay, I gotta give my Georgia folks their congressperson. I gotta give my Georgia people that. Georgia folks, we need to get together and get this stuff going for over here. We can't let Texas outdo us. I have not
our
even sent
sen-
an email yet.
our senators are Ted Cruz and John Cornyn.
Okay, let me see Georgia's senators. Hold on. I know New York is
Which,
Schumer is one. Schumer is one. Oh, you're in Columbus, Georgia? Okay.
I'm gonna put it in caps. Texas Congressman.
The priest. Can one of the mods put that petition, the Mann Act petition, in there for me, please? The one that Tina Trina did, the Mann Act one.
Let me find their phone number.
So, what do you do, and what can you do for all people? What do you do, or can you? Oh, we have an email. Graham, didn't you give me the email for Georgia? Is it an ATL?
Yes, yes, it
Here's
is
an
Team
email.
Kells. Hmm?
Okay. And
Team Kells ATL. Sorry.
God for Glam, I'm gonna give you the access to that email too, so you'll be able to get in. Because I would like you and I and somebody, one more person to spearhead the Georgia folks. Oh, PDQ, did you want to Did you want to I want it to be three of us, so when one doesn't not able to get in, the other one able to get into the that email. I want three of us. One from the east side. Well, it should be four of us. One from the east side, west side, because I'm on the east side. South side, we need the north side and the west side. Yeah, I know. Yeah. So which side are you? South side, east side, west side? I'm on the east side.
Oh, I think Colin Allred too, guys. He's a member of the House of Congress. Let me see. I'm gonna put it in the chat. He's a
Guys,
black gentleman.
Guys, what we need to do is start putting in the state that you're from so other people could connect with you. And you guys could go into that email and they could connect with each other. That's the way we're going to do. We're going to do this grassroots movement, small grassroots movement, because for my information, you don't have the petition. Okay, for my information, Choke No Joke is getting in contact with someone how to get a petition moved. I do have some Congress personnel that I personally know that I can ask them to come on here. No, I'm saying that you can, saying for you so you can have a list of all the Georgia people if you want to pick a day and we can go. Okay, okay, that sounds great. But our email, there is an email that we have already that I would like you, if you don't mind, Gospel Glam, to be part of the inside of looking at that email, if you don't mind.
And for my Texas peeps, I just put a link in real quick for you to find all of our members of Congress. So, Miss Sylvia, let me put one in for Atlanta.
Okay. You
Georgia.
South side. I'm South. I'm East side. PDQ, which side are you on? I'm on the
I'll just do Georgia Congressperson. I'll do the website and then you can find, wow, your congresspersons for Georgia.
It should be Johnson, if I'm not mistaken, for the Democratic side.
Yeah, and there's different districts. So this website will have what district you're in. Do you know what I'm saying? Like you may be where you live, you may be in district, do you know your district's 12 or 10 or something like that? That is for Georgia, guys.
I personally know my person.
You do? Yeah. So where's the petition? Because the one that
there's a petition right there. There it is right there. Red Bunny just put it there. That is right there. Guys, just click the petition that Red Bunny just put up.
Ah, man.
Okay, PDQ is north of Atlanta. Okay, we got north, we got south, we got east, and we just need a west person. Who's a west person in Georgia? Thank you, TK Moss. I haven't seen you in a while. Thank you, Jay Lewis. Guys, if you haven't signed the petition, please sign it and forward over, share it with others. If you have not signed the petition, because we're trying to get 1,000, I sent that over to Choke last night when he was asking for that petition. Black Beauty, which one is that one? Is that another petition? Please sign the petition and forward it over. Please sign the petition, forward it over.
Guys, there's only 249 signatures, 250.
Tanya's, Denise is asking for the Illinois one.
Okay. Congress people?
Yeah.
Okay. Hold on. I'll send it to him.
Guys, could y'all put the state that you're coming from? You don't have to put your city. Just put the state so we'll know that where you are. Just put the state. Just the state.
Yeah, because the website will allow you to search your
You have Oklahoma here. Try every time you come in these chats, try to put down a state. We got Tennessee, we have Texas, and there are Tanya. If you don't mind, could you put all the emails that for each state that we had? Because we're doing it by region. We have the Atlanta region. We have, I think, did you do Chicago? Did you do Illinois?
No, I thought Illinois had theirs already. I'm not really sure. Let me see. I'll check and see. So this right here, this link that I'm about to drop is your Congress people and your for Illinois, right? And so yeah, there it is right there. Mississippi, Michigan, California. Okay, let me do California. So what I'm going to do, guys, is I'm actually going to draft a letter or email what needs to be sent to that person, to your member of Congress, right? So that we can be uniformed. Does that make sense, Miss Sylvia?
Sure. What I'm gonna do, I can show it once you complete it. I can show it on my community chat. That's it. Mimi got it. I was gonna put it in my community chat, but Mimi already said it. I was gonna put it in community chat whenever you have it now.
Okay. So I'll work on that today, and then what we could do is just flood them with these letters and emails, right?
Yeah.
Because our letter and our email can say the same thing. We can pretty much copy and paste and put it over an email form or whatever. And also letters or whatever, and phone calls and what we should say to them. And also send them attach a copy of the petition for the Mann Act. I don't know.
You know what I was also thinking, because a lot of them are trying to run this little for position, like push it out to those who are getting ready to run for some sort of
voting in our state was yesterday. Well, it was voting time yesterday for everyone, right?
Yeah, but then they had next year. There's going to be another set of people running for something, because everything is like everything.
Do we know? Yeah. Do we know what happened with Spit and Fire's one? Because she had one, right?
Yeah. I tried calling her yesterday. I left her a message because her and I are supposed to have a meeting. So I'll let you guys know what our meeting, whether or not we were able to meet, because we were supposed to be picking. And I did pick you, Tanya.
Thank you, man.
Her and I mean, we said two people, and I did pick you. She says somebody who I'll talk to you about it later on.
Okay.
I picked you, and I picked another person to
our congressman in Oklahoma. Okay. So Jennifer, what we're doing is we're getting people to sign the petition that's in the chat. If you can go look in there and see the link that Black Beauty posted to sign to abolish the Mann Act. We are also putting in links for our congressmen for our particular state so that we could reach out to them and share with them this petition, possibly about the Mann Act, and just tell them how unfair it was. I don't even know if we need to I would not mention R. Kelly in those emails or letters, because again,
we're doing it for all men.
Yes.
Yeah, we're doing it for all men.
Yeah. And again, you don't want them to see that if they've been swayed to think otherwise of him, for them to not even look at it once they see his name. Because again, like Miss Sylvia just said, it's bigger than Robert at this point.
Yeah, it has to do with them reaching and getting something that is so old, 111-year-old law, to try to convict somebody. And that it's just not just Robert. It's other individuals that they could be using that same law, and that's not right. They need to get something totally, revamp that. Totally revamp. There's a lot of laws that's on the book that people have never even looked at, and now this is one opportunity for us to take a look at that. Because remember, Trump did pardon Jack Johnson on that law. So if he could pardon, that means it could get abolished, because that's something that don't need to be on a law book.
So Mark Tramp said to look at YouTube documentary named Jack Johnson, The Mann Act, and you will see the similarities in this case. I will
Okay.
do that too.
Well, I don't see what he says. Okay, okay, right here. Mark.
Mark,
Thank you,
yeah.
Mark. Maybe we'll take a look at it on my other channel because they be trying to smash you down on this channel. So hopefully you could look at it.
So the next state that we're doing a petition is Chicago.
The rally.
The rally, yes. Sorry.
I gotta check with Choke and find out if he's doing it. In let me send him a message.
Yeah, my husband wants to send me away he said I need some away time. So,
Oh, so you're gonna come to the next rally?
yes, because he just told me last night, I need you to go do something for yourself for a week or whatever, a few days, and just get away.
What?
So,
Okay,
uh,
yeah. We're gonna do this rally. That sounds
yeah,
great, right?
yes, I need to know so that I can go ahead and schedule my flight. Hey, Mimi, baby girl. I know it's going to
Um,
be cold.
yeah, what
So
I
if
need
it's,
for you and I to do today, so we can bring it to the people later on today, we need to research how the whole petition thing for us to get it to Congress type of thing goes.
how we do that?
I want us to
See how we do it or what?
yeah, the process.
Okay. All right. All right.
That's gonna be our homework on the next live that we do. But anyway, guys, I'm about to go because I don't want to stay on here forever because we got others live to do. Because yesterday I did not do any lives, and I want to make up for
You
yesterday.
slipping, girl. You
Yeah,
slipping. You
no, I needed
slipping. You
off.
slipping.
So
No,
where
I'm
I
just
was at,
kidding.
where I was at mentally, you probably would not like Sylvia now. You don't probably like her a little bit now today too, because I
Who,
still.
me?
No,
Me?
I'm just saying in general.
Oh,
The people
yeah.
won't
I
like
love
me.
you, girl. I love
I
you.
know you love me. I love you too. There's
Thank you.
quite a few people I know love me because they were reaching out to me yesterday, left and right. They were reaching out. Okay, girl, what's going on? And Henny Hen, I am fine. She's been
I
looking
was
for me.
scared too because I was like, I know she's taking a break, but if I don't see her butt on here today, we're going to have problems.
No, I was ticked. I was ticked. I stayed in my behind the scene with my other folks, and I had them muted throughout the whole time. They thought I was listening to them, but I wasn't. But Mr. 444 Smiles, where have you been?
We need to hear your voice, sir. Are you
Yeah, come
okay?
on in. Come on in. I don't like not hearing your voice.
I know, right? We
Come
need
on
to,
in.
Mr. 444, get your
Come
butt up
on.
here.
Hey, Michael. Michael's here too.
Hi,
Where Ivan? I need my Ivan. My other me, because they saying that Ivan is me. Where me at? Where my other me? Where
Mike. Oh my
me
gosh.
at? Ivan, me. Sylvia Ivan, infamous Ivan. Come on out.
Mr. 444, did you hear us, sir? Click that link. Denise, I'm so happy your blood pressure is back to normal, girl.
Yay, Denise. Don't let this stuff get to you, Denise. Do not let it get to you. See, that's why I keep my blood pressure machine right here next to me now. Because, every time these folks get to me, I got to take my pressure. All the nurses in this chat here be like, what's your pressure now?
Mine's is always so low, which I heard low is just as bad as
Hi.
high.
Yeah.
And I'm not sure what's causing it. My doctor, he said it could be what do you call it? Oh my God. Where
Travel
your
the
blood
world.
is low.
Travel the world. I'm ignoring you. She's wondering, we'll get my pressure up. I'm ignoring her. Hey, Natty. Hey, Nadine. Nadine. I'm sorry. Hey, Nadine. I'm ignoring Travel the World. She will get my precious up.
What she make? No.
Travel the World gets my pressure up. Hey, Dallas. Hey.
She
Dallas.
gets
Oh,
your
hold on a
pressure
second.
up.
Oh, hold on. I got to mute you up for a second.
Red Bunny, you said I should eat more bacon to get my blood pressure up. Like my numbers are always double digits on both. Like my top number is really low most times.
Hey, Nadine. As far as Dallas, they said you get my blood pressure up. You get my blood pressure up. You get my blood pressure.
Yes, I am anemic.
I love you too, Denise. See you later, Glam. Deborah, I looked for you this morning. Where were you? We missed you this morning. I sent you a text.
I love you too, Denise. Have a blessed day, honey.
We missed my prayer warriors this morning. And all my people in the bushes, you know who you are. Thank you so much. I appreciate you. I appreciate you so much.
You
I love
guys
you
stop.
too, Latrice. Latrice, I know you've been looking out for me. Look, she was on the line looking out for me, having Tiffany look out for me. Okay.
Jay Lewis, sometimes I have to have infusions. Iron. It's not fun.
He said you need today to take vitamin C, 12, and iron. Hey, Matt. There she go. There go my girl right there in the bushes. She's in the bushes, y'all. Where my other? Where's you digging me at? I saw Miss Fat. Where's Miss Nakia? Where's Miss Fat? Where Big Marshall? Where
Miss Sylvie. So Travel the World wants to know, what in the heck did she do to you?
I'm not talking to her.
What?
Mm-mm.
Click the link, Travel the World.
Don't let her click the link. I don't want her in here.
Since Mr. 444 came in and left, we don't even know if that's really you, sir. We need to hear your voice.
Thank you, Tish.
She said she didn't do nothing to you, Miss
She
Sylvia.
never do nothing. Absolutely. She never do nothing. Never. She don't take responsibility of her actions to me. Oh, there she come.
Marshall.
There she come. Watch. Here she come. There she come. What?
Marshall, you're in the bushes back. Good to see you.
There she come.
Sylvia, what the hell I do to you?
Miss Mimi, you're gonna be a doctor in 3 weeks.
This is not the
My
cousin Colonel, ma'am.
goodness.
What I do to you, woman? What I do to you, woman?
Making my
I'm
blood
gonna have to
pressure
call
going
you,
up,
Mimi.
y'all.
I thought we were sisters from another
I'll
mother.
give you my number,
My
Mimi.
blood pressure going up, y'all.
Travel the World, what you do to her?
I ain't done nothing to Sylvia. She tripping. I thought we were sisters from another mother. See, she done distant me already.
She loves you. That's why she's
I
saying
know
that.
she do. I know she do. That's why she not messing with me, because I know she do. Sylvia, you better say something.
She being honorary today.
Yeah, she be here with the stank face today.
Tanya,
She'll
is
be.
somebody talking to you, Tanya?
Yeah, Mimi says she says she'll be a doctor in 3 weeks. Congratulations, Mimi.
Miss Sylvia,
What's up?
why you got the stank face on today?
What do you want? What do you want? What do
You,
you want?
what I do to you, woman?
Nothing.
Okay, well, why you telling all these Why you telling all these folks I done something to you?
Where you been? Hey,
What did
Karen.
Gail King say? Nadine, what did Gail King say?
When
Oh,
that
Jazz, did you have a reflection of her interview with that
N-
girl?
I don't know when.
I saw something pop up on my thing saying that she had a reflection of the interview. What did she
We
say
love
about?
you too, Denise.
Huh?
Sylvia,
Huh?
you on the East Coast, I'm on the West Coast. When you go on live, I be sleep.
East Coast against the West Coast.
I be sleep.
You're welcome, my love.
So you
Mimi.
need to go on live around about the time I get off of work, which is 5:30 my time and 7:30 your time. Then we can holler about it. We can talk about it.
Good, congrats, my girl Mimi is getting her doctorate. Woo woo! Oh, there she go. There go my girl. There she go, y'all. There she go. My
Look,
trouble.
she's still ignoring me.
I'm not ignoring you. I'm talking to you, digging me. I called her and she came out.
Can we get everybody in the chat to say congratulations to Mimi for
Yes.
getting ready to be a doctor in 3 weeks? That is hard
So we could
stuff.
just make sure you change your thing to Dr. Mimi. Dr. Mimi.
Congratulations, Mimi. Mimi, aren't you in California?
No, she's from California. She's in Mexico.
You
Oh,
digging me where you been? Because I've been listening to your channel every day.
Look, yes, you dig me. You have some faithful listeners. I listen to your thing at night to get me to sleep. Yesterday, it helped me out yesterday because trust me, these folks have me going.
where's Mr. Missing in action and need a muzzle?
He's at work. They got him at the office now. They got him in the
I
office.
told him I was going to give him a muzzle for his birthday.
So we need to hear what Gail King's. Can you find that?
It popped up
Sylvia?
on my phone. Hold on, let me check. It popped up on my phone this morning, but I didn't pay attention because they said Gail King. Hold on.
What
Hey,
Gail King done
everyone,
now?
send it to me.
She,
What Gail King
I
done
don't
now?
know. Maybe she retracting her feelings about somebody. We don't believe you, whatever you said, but we just want to
Say,
hear it.
okay.
Whoever has it, send it to me, please. Send it to me because I saw it this morning and it popped out.
To me, she's what Snoop Dogg called her. I ain't gonna say nothing, but y'all
Okay.
know what I'm talking about.
Rhoda, I've been looking for you. Where
I
you
know.
been?
Look, are you getting amnesia?
I know you sent me a message saying that you went to Michigan because your friend.
Yeah, I left. I flew out last Thursday, and I just got back late Monday night.
You just been gone so long.
I know, and I was like, and while I was there, I was like peep in every now and then. I couldn't stay, but I'll peep in and see what y'all was talking about. Then I dip back out. Yeah, I'm like, I'm so lost. It's like I've been gone all that time, and so much is going on. I was like, well, she'll have to catch me up. She'll have to catch me up. Yeah.
Oh
So
yeah, I really want to hear this idiot.
everybody been doing okay?
Yeah.
That's good. That's good. Yeah, I'm working now, but I was like, let me just step in and tell her because I knew you had asked. I think yesterday. I said she getting amnesia. I told her.
No, I didn't get. I knew you said that, but you've been gone too long.
Oh yeah, I went back and looked at the rally yesterday. I was watching most of the rally.
Now, did you see his production of it? Oh my God, it was nice, clear, not messed up like mine.
Oh, okay. I'll have to pull up.
You have to look at Choke's. You know what?
Answer me! Hello?
Oh,
this
Lord.
is your cell phone! What do you think? You're just not gonna answer me? You keep me in your pocket like I'm some dirty little.
This look crazy. Okay. I'm trying to
Answer me! Answer me!
I know that. I'm like, I forgot my mic is on. Okay, we gonna put you on.
Hold on. They send it to me. I thought it was okay. She says here, Gail King calls the R. Kelly verdict justice. Verdict justice says the survivor's testimony was stomach churning. Really? Wow. Gail King calls the R. Kelly verdict justice. Wow.
Wow.
The CBS morning anchor, whose March 2019 interview the singer went viral, spoke to Bustle about Kelly's September 27th conviction on all the charges, including 1 count of racketeering and 8 count of violating the Mann Act on interstate anti-sex trafficking law. The bump and ground singer, 54, faces up to 10 years to life in prison for physically and sexually abusing women and minor over a period of decades. Justice King said her immediate reaction to the verdict, "That's what I thought." Wow. Wow. The newswoman continued, the judge said some of the evidence were so disgusting and despicable that they wouldn't even allow it to be played in the court. That's not what the judge said. Y'all, they making up stuff. The judge never said that.
I heard that I saw that on somebody else's blog that that's what was reported that some of
that judge did not say that.
No.
I was there. The judge did not say that. Hold on. Let me get Dottie. Where Dottie? Dottie, if you're in the bushes, come out. Hold on, y'all. Unless I got amnesia, the judge never said that. You just claimed I had amnesia, right?
Right.
The judge did not say that. In fact, the judge would not allow the defense stuff to be brought out.
Well, you know, Mr. Bird done got around that he done hired Bill Cosby's appeal lawyer. You know, now they trying to put out a little narrative again, just like before. So that's all that is. Yeah.
Wow, man. The judge never said that. Hold on a second. Let me call Dottie. Hold on.
Okay.
Talk to the folks, Rhoda.
Hello, people. Hey, 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 hey. Terry, if you're in the bushes again, happy belated birthday. Hey, what y'all been up to? Y'all having a good day so far? Hey, Jocelyn. Hey, K baby. Lane. Shell, Latrice, Bird, Kimberly, Mimi. Let's see who else. Nadine, Groovy Family. Mimi, I think I said that. Tanya. Where'd you go, Tanya? PDQ, Kimberly, Valerie. Meditation and chakra balancing. She said we need to meditate. Whoever that is said we need to meditate. Sun, Lori, Carolyn. Hey, Carolyn. Again, congratulations to Dr. Mimi on getting that doctor's degree, doctorate. That's awesome. Y'all hearing the clicking? That's me text chatting. I'm at work listening. Supposed to be listening in, but I'm on here talking to y'all. You and me both, Tanya. I'm sick of her too. I agree with you, Matt. She has something against black men. That I do believe. Yep. Hey, Latrice. Mr. 444, you're not feeling well? We pray that you get to feeling better. Hey, Raquel. Exactly, Tanya. I think all of them trying to take their frustrations out on Robert. Hi, Ivan. Miss Sylvia's on a phone call, so I'm kind of like talking until she returns. Oh, you have the sniffles? Yeah, you have to take something back for that, before it turns into something else. We gained that hour back this weekend. I'm looking forward to it. Are you taking anything, Mr. 444? Hey, Denise. That happens to be my middle name. Black Beauty. Hey, Tina. Miss T. London. Well, you're welcome. We like to hear you speak, Mr. 444, so we can't wait till you get better. Tanya's back, yay. Tanya, you can be talking. He said he want his mama. Hey, Trish. Stats.
Can y'all hear me?
I can. Mhm.
Wait a minute, I can't hear you.
Sorry, guys, I'm back.
Okay, good.
Hold on.
Hey, Rhonda.
Branda's in here. Hi, Brenda, baby. Hey. Watch your mouth, lady, in this channel. Watch your mouth, lady. Stat. Okay, guys, she did not answer. I called her twice. She did not answer. Hey, the terminology, how you're using damn is not the right way. She said, damn is in the Bible. She always started trouble. All right, guys, I'm gonna end this live because I can't get Dottie to talk to me regarding to what this lion lady said, what the judge said, which the judge did not say it. So Musa, I shall digress. But we will be back, me and Tanya, with the other part of what we wanted to bring to you guys. So I will chat with you guys later, but we're going to go to the other side because, you know, the other side needs some release.
All righty.
All right, guys. I see you.
Going now?
Huh?
Are you going over to the other side now?
Yeah, I'm going to the other side now.
Okay. See you
Let's go field trip, people.
Field
Let's go
trip.
to the field trip.
Bye.
Bye.